come closer. Okay. On the record in State of Michigan versus Rodney Jerome Jr. Smith. Appearance, please.
Yes, Your Honor. Good morning. Assistant Public Defender Stephen Feigelson on behalf of Rodney Smith this morning.
And you, sir, are you Rodney Smith?
I am Rodney Smith, but I kind of actually wanted to go ahead and handle it myself. I actually understood it. I didn't mean to ask for a defender. I do apologize. I was just trying to go ahead and handle it. Okay.
Yeah, I don't know what you think you're going to accomplish, but I'm going to go ahead and start the arraignment. Mr. Smith, what I have here is a felony complaint. This alleges that on or about June 7th, 2025, at a location of 413 South Cedar Street in the city of Lansing, you did make an assault upon Cole Harrison Corner with a dangerous weapon, that being a knife, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That is a felony punishable by 4 years and or $2,000 with DNA to be taken upon arrest. Count 2 alleges that on or about June 7, 2025 at 120 West Michigan Avenue, City of Lansing, you did assault, batter, wound, resist, obstruct, oppose, or endanger Teeson Graham, a police officer of the Lansing Police Department, that you knew or had reason to know was performing his duties. That is a felony punishable by 2 years and or $2,000. A consecutive sentence may be imposed if the assault was committed in a place of confinement or for any other violation arising out of the same transaction. Do you understand the charges and the possible penalties? You have the right to have an attorney in this matter. If you can't afford one, we'll see if the public defender will represent you. You have the right to a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand your rights so far, Mr. Smith?
So far, yes, Judge.
Are you going to want a public defender to assist you in this case?
Like I'm innocent, and so I actually really agreed to not actually have one.
I'm sorry, I didn't hear the first part of it. What did you say?
I said, Judge, I'm innocent, so I'm going to agree to not have one. It's seriously all right for me to actually just really look at this situation differently because I actually really didn't understand what was,
Okay, but if you, even if you're asserting your innocence, you're charged with 2 felony charges, and you're going to be going up against a prosecutor who has at least 7 years of training. Are you sure you don't want a public defender to assist you with that?
Judge, I can take it all the way up to trial, if anything, because it's really seriously something that really wasn't irrelevant. It really wasn't anything that couldn't be handled. Me carrying my own, merchandise.
No. See, you're going to make admissions right now. As I told you, you have the right to remain silent. Anything you say orally or in writing will be used against you in court. So if you start saying things like that, it's going to be used against you. Again, the whole reason why we offer you an attorney.
Judge, I did complete an application with Mr. Smith. I do advise that we at least proceed with that and see how it goes.
Mr. Smith, since you have felony charges, you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe the felony occurred and probable cause to believe that you're the person who committed the felony. Before you go to preliminary examination, you're going to have a probable cause conference, a day where you and the prosecutor and your lawyer, if you have one, make sure you have all the evidence and information you need to be ready for preliminary examination. Your probable cause conference is scheduled for June 20 at 2 o'clock. That's scheduled with Judge Simmons, but I happen to know Judge Flores will be covering her docket that day. And then preliminary exam is set for June 27 at 9:30, also with Judge Simmons. That is an in-person hearing because evidence and testimony may be presented at that time. Mr. Smith, are you on probation, parole, or bond in any court?
I am not, Judge.
Okay. The address they gave me for you on Perkins, is that a good address for you?
So far, yes, it is.
What does so far mean? Are you able to?
I'm working on it. I'm just working on it. I'm just slowly building my house, and I got detained for no reason at all, and it was seriously illegal for him to actually detain me. So, I'll just go ahead and go forward with what you're saying.
So the Perkins address you can receive mail at.
I'm pretty sure I can actually just go ahead and actually make sure of it.
What's the phone number to reach you at?
I don't have one, Judge.
Okay.
Still working on it. I do apologize.
Mhm. Looking at your Michigan criminal history here, it shows 2021 operating while visibly impaired. 2019 driving while license suspended attempt. 2021 disorderly person. That's everything.
Nothing done.
I guess, Mr. Smith, if you don't want Mr. Feigelson to speak on bond, then I'm just gonna go ahead and set your bond. If you want to let him speak on bond, I will let him speak to me about bond.
Oh, can I actually go ahead and allow you to actually go ahead and actually pursue so I can actually understand it? Because I actually really can't, I kind of actually really want to go ahead and handle this one by myself. I didn't understand it because I actually really wanted to go ahead and look into it. To actually just go ahead and actually just get a feel for my my rights to actually just really be mine in there instead of giving my rights to someone totally different. I'm not mentally ill, so I'm just trying to just go ahead and actually just cooperate and actually just be the only one on my own case and actually understand my rights and everything that actually really needs to be counted.
Well, I've been advising you of your rights, and then you say you don't understand, which is all the more reason why a public defender would be probably helpful to someone who doesn't understand everything. So that you have someone who's in your corner and can help explain stuff to you.
Well, it was because it was an illegal detainment that I just didn't understand.
Mr. Smith, please do not talk about your case. This is being recorded.
I didn't. I do understand you, but please
Mr. Smith, stop talking now. All right, based on my review of Mr. Smith's criminal history, which doesn't really have much assaultive on there, closest thing is disorderly conduct. However, the nature of the charge involves an assault alleging a weapon and also alleges some uncooperative conduct. I find that personal recognizance bond is not sufficient to assure appearance in court or public safety at this time. Bond is set at $5,000, 10%, subject to the following conditions. You must appear for all of your court dates. I've given you 2, June 20 and June 27. Do not leave the state without permission from the court. Do not commit crimes while out on bond. You must notify the court in writing of your address and telephone number. You are required to make a report to pretrial services the first business day after your release and any time thereafter they've requested. You should get a brochure there from the jail with information for pretrial with their phone number and address so you can report to them. Do not use alcohol or illegal drugs. Do not possess a firearm or any dangerous weapon. You can have 0 weapons while on bond. If you have those things, you need to give them to someone else for safekeeping or give them to the police, but you cannot have them. Do not engage in assaultive, harassing, intimidating, threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten Cole Kerner. You are not to have any direct or indirect contact with Cole Kerner. You're not to be within 2,000 feet of where he lives, works, or goes to school. It's my understanding this event occurred at his workplace, so you're not to go within 2,000 feet of the 413 South Cedar Street because that's where Mr. Kerner works. If you violate the order of no contact, you're subject to arrest without a warrant. This bond could be revoked. You could be in contempt of court, for which you'd be sentenced to up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. Do you understand your bond, Mr. Smith?
Mm-hmm.
Okay. We've covered the charges, the court date, the bond, the conditions. Mr. Feigelson, do you think I've missed anything?
No, Your Honor.
All right, Mr. Smith, you're all set.